Our Constitution is a living document and is growing, albeit as a Constitution, it's still very much in its infant stages. For example, with regards to the question of the separation of power, the Council of State and local government, these are areas that we can look at if we decide to embark on some review of the Constitution. But with regard to the separation of powers, it's a well-flogged horse. And the argument is that the executive being chosen for the legislature offends against the doctrine of separation of powers. The proponents of that view call for a strict separation of powers, where the executive, the legislature, and the judiciary are separate and distinct arms of government. This doctrine of separation of powers, which was first properly formulated by the French philosopher Montesquieu, was formulated to check the abuse of power and to protect the individual from such abuse. The rigidity and purity of the doctrine of separation of powers is no longer the case, and various arrangements have been formulated to ensure that the power of state is kept in check. For example, in Ghana, the Constitution established Commission on Human Rights and Administrative Justice is mandated by Article 218A to, among other things, investigate complaints of violations of fundamental human rights, injustice, corruption, abuse of power, and unfair treatment of any person by a public officer in the exercise of his official duties. Article 33(1) also gives any person the right to seek redress in the High Court where the person alleges that a provision of the Constitution on fundamental human rights and freedoms has been, or is being, or is likely to be contravened in relation to him. That person may apply to the High Court in such situations for redress. These are but two examples of provisions of the Constitution that provide checks and balances to ensure that the individual's rights are not abused by the state. An argument for the strict division of executive and legislative power contradicts or is in variance with those who advocate for what they call the Westminster type of government, where all the members of the executive are part of the legislature. In fact, the former Prime Minister, David Cameron, was made a member of the House of Lords so he could sit in cabinet. So now he's Lord Cameron. Today, we have a situation in our Constitution where some ministers are members of Parliament. In 1969, we practiced what was called the Westminster form of government. In 1979, we practiced what was called the Republican form of government. And all of us know what happened in 1979, which led to the overthrow of the government. So today, we are practicing a combination of both. It is based on our history. Let us tread cautiously and with caution, and don't let us be in a rush to torpedo our current constitutional arrangements.